trial, and you mentioned that other hearing. We expected this morning's proceedings to start with what was called a Sandoval hearing, but it appears that the jury selection is beginning before we get to this part. Now, we expect that to happen potentially at some point today here, but what this Sandoval hearing, when you hear that term come up here in the hours ahead, is an opportunity for the district attorney's office to get an understanding from the judge about what other trial determinations, previous trials, for instance, potentially the E. Jean Carroll trial or the civil fraud trial, they would be able to bring forward before the jury during cross-examination if, in fact, Donald Trump testifies. And the judge would be the one, once the DA presents what they would like to bring forward to the jury, the judge is able to make that determination at that point of what is germane or relevant to this case. Of course, the legal team for Donald Trump has fought back, saying that they should stick to just this case alone and not be able to bring up other trials from the past that Donald Trump has been engaged in for the purposes of not tainting the jury pool's view of Donald Trump. But this is sort of this ongoing piece here where we could be still several weeks here before the trial begins, knowing that the Sandoval hearing must still take place, as well as this jury selection, which is slow and very much methodical. Anna?
Vaughn, stay with us. Let's bring in Chuck Rosenberg, former U.S. attorney and senior FBI official, along with Charles Coleman, civil rights attorney and former prosecutor, and Jessica Levinson, attorney and Loyola Law School professor. So, Charles, let's start where Vaughn just left off. Help us understand this Sandoval hearing. What is it exactly, and is it typical here in New York for a defendant to get sort of a preview of the type of questioning they could face on the stand?
Absolutely, Anna. This is something that is standard procedure when you're talking about criminal trials in New York, particularly ones where defendants may take the stand. You have to give their defense team an opportunity to assess what is the extent of the bad acts that they, number one, seek to ask about, and then number two, whether the judge is going to allow that information in court. The reason for this is because once you have had that information presented in front of the jury, whether it's objected to or not, it can be incredibly prejudicial. You cannot, as we say, unring the bell. So before you even get into trial, you want to make sure that there are limits and understand what those limits are if you're the prosecutor in terms of what you can ask about and what you can't. And then as a defense attorney, you want to have the opportunity to understand the contours of what they will be able to ask about so that you can either object and or prep your client or talk to your client about not testifying. So this is standard in New York. It's not something that is a surprise. It's a routine hearing that occurs almost every time that you have a trial when you're talking about a defendant who may testify.
So, Chuck, one of Trump's lawyers, who is not representing him in this case specifically, suggested it might not be a bad idea for Trump to take the stand. Take a listen.
What do you personally think? Do you think he should get up there?
Well, as one of his attorneys, my personal view really isn't in question
What's
here.
your legal advice to me?
I would say that, I think President Trump would be a very compelling witness in this case. I think his testimony would be able to explain, as other witnesses' testimony would, that he did nothing wrong here.
Chuck, what's your reaction? Do you agree?
I don't. I was a federal prosecutor for a long time, Anna. First of all, very few defendants take the stand. When they do, and it's rare, it tends to be a very bad idea. But let's be clear, sometimes it works, and it's absolutely Mr. Trump's right to do it if he so chooses. But I fundamentally disagree that he can make a good case for himself. With all of the statements he's made, all the false statements, all the contradictions, all the discrepancies, I think he would be a ripe target for a good cross-examination.
Jessica, weigh in on Trump taking the stand.
I think that comment by his attorney was meant for an audience of one, Donald Trump. You can't be his attorney and say, you know what, I think he would just absolutely implode on the stand because he's a pathological liar. And so I didn't really take that to be serious legal advice. Frankly, I agree with what was just discussed. It's a Hail Mary oftentimes for any defendant to take the stand. And a lot of times you want to wait to see how strong the prosecution's case is. We've heard time and time again from the former president, I want to tell my story, I want to take the stand. And then when push comes to shove, that doesn't always happen. So I think if you if you imagine a person who would be subject to a really stinging cross-examination with a lot of statements that you might not want to be confronted with, you have a picture of Donald Trump. He has a right to do so, but I don't know that legally it would help his case.
And Vaughn, let's go back to you. Give us an update as to what is happening right now as today, day 2, gets underway.
Right, to give you an idea here, the first juror of the morning to be asked that 42-question questionnaire is currently responding to questions. And if you go back to yesterday afternoon, nearly 2/3 of that first batch of 96 individuals that could be potential jurors said that they felt like they could not be fair or impartial and were promptly dismissed. That is what is unique about here. This jury selection process here is that if an individual, without even giving a reason, says that they are unable to take part in this trial, they were allowed to leave. But this individual, this juror who is currently in the trial box answering questions with Donald Trump sitting right there, got to question 21 and was asked about potential impartiality. And I just want to let you hear from part of this individual responding, "I can't be impartial because I may have an unconscious bias. Growing up in the state of Texas, I believe I have an unconscious bias. A bunch of family and friends are Republicans." That individual has been excused. And so that juror will be replaced by another potential juror, and the next round of questioning is going to begin.
Charles, Donald Trump is very well known, especially in New York. It's pretty reasonable that jurors would say they can't be fair and impartial. So just how difficult is it going to be to try to fill this jury?
You know, Anna, I think that this is going to be a challenge. I've said that this is going to be a challenge for a long time, and some of my legal colleagues have disagreed. People can say that they will be fair and impartial, but there is a very big difference between being in a room with the former president, having any sort of inclinations or strong feelings about him, and sitting in that space. And I think that that reality hits a little bit differently for a number of prospective jurors. I also think that there's the notion of, and I'm very concerned, quite frankly, as a former prosecutor, with the notion of a stealth juror. And for those in our audience who may not know what that is, a stealth juror is someone who says all the right things. They want to get on the jury. They desperately want to get on the jury because they've already made up their minds and they have decided whether they are going to convict Donald Trump on all counts, whether they hear the information or not, and regardless how, or conversely, with whatever is presented by the prosecution, even if they don't meet their burden. I'm sorry, even if they do meet their burden, there are some jurors who want to get on and just to try to acquit Donald Trump. So, you know, this is something in terms of the question of being fair and impartial that is a very real thing. It's very difficult. It will get done. But it's going to take time, and it's going to take vetting and a very honest voir dire from both the prosecution, the defense, as well as the judge to be able to use the cause challenges that they have, as well as the preemptive challenges that they have.
And so, Chuck, when Charles talks about these stealth jurors, that's got to be in the back of the minds of both sides, the prosecution as well as the defense. And you say that it is sort of a routine defense strategy to play for a mistrial, and that starts with this jury selection process. Can you explain?
Yeah, right and right. So in order for a defendant to be convicted or acquitted, the jury has to be unanimous, 12-0. Any other numerical breakdown, 11-1, 10-2, any other breakdown, Anna, is a hung jury, a mistrial. Now, if your goal is to be acquitted, a mistrial doesn't really help you do that. You're still a defendant and the government can retry you. If your goal is to try and kick the can down the road to buy more time, to incur delay, a mistrial can be very helpful. And so I think it is a routine strategy, and I don't mean that it's underhanded in any way, for a defense team, defense lawyers, to try and find a jury that may hang. Of course, they're trying to avoid conviction. Of course, they're hoping for an acquittal, but those are rare in jury trials. But what they are looking for is, as Charles said, that stealth juror who perhaps could hang the jury, ensure that it's not unanimous, create a mistrial, and give Mr. Trump more time, by which he might be president and be able to avoid a second trial altogether. So a possible strategy.
For now, Jessica, Trump has to be in court every day. This is a criminal trial. Those are the rules. Last night, he was complaining on social media about the judge rejecting his request to miss court for his son's upcoming graduation and the upcoming Supreme Court arguments on presidential immunity, which happen next week. What do you make of the judge saying no?
I think the judge, this is not the judge's first criminal trial, and the judge is treating the former president like he would treat other criminal defendants. And what he said is, you're a defendant in the state of New York, and here's what I don't allow people to do. And therefore, and of course, I'm paraphrasing, this is what you're not allowed to do. You don't get to say as a criminal defendant, you know what, there's another court case that I don't have to be at, but I'm just interested in Washington, D.C., in the Supreme Court. You don't get to say, I'm sorry, I have a family obligation. Now, of course, there are moments where a judge can decide to, quote unquote, go dark, and where an attorney or a defendant or a witness can't be there. But I think we've seen all along that this is a judge who knows how to run his courtroom, is taking this case seriously, and is going to do his absolute best to the extent possible to treat this like any other case and any other defendant.
Jessica Levinson, thank you so much. Von Hillier, Chuck Rosenberg, Charles Coleman. Stay close, guys. Still ahead, Trump's name has been on Manhattan skyscrapers for decades. His life chronicled on city tabloid covers. So how do you seat a jury in the city that made him? Plus, campaign split screen. While Trump's stuck in court, President Biden prepares to hit the trail. How the case is upending the race. But first, when we're back in just 60 seconds, breaking news at the Supreme Court. Justices hearing a January 6th case that could have legal repercussions for Trump.
Nothing dims my light like a migraine. With Nurtec ODT, I found relief.
The only migraine medication that helps treat and prevent all in one.
To those with migraine, I see you.
For the acute treatment of migraine with or without aura and the preventive treatment of episodic migraine in adults. Don't take if allergic to Nurtec ODT. Allergic reactions can occur even days after using. Most common side effects were nausea, indigestion, and stomach pain.
It's time we all shine. Talk to a healthcare provider about Nurtec ODT from Pfizer.
My frequent heartburn had me taking antacid after antacid all day long. But with Prilosec OTC, just one pill a day blocks heartburn for a full 24 hours. For one-and-done heartburn relief, Prilosec OTC, one pill a day, 24 hours, zero heartburn.
We decided to put in an in-ground pool.
I literally went on Angie and typed in pool.
Getting to talk to different contractors, see different bids.
We wanted something beautiful. We wanted something that our children would feel happy swimming in.
And we love it.
Get started today at Angie.com.
Breaking news from the Supreme Court this morning. The justices are preparing to hear a case today on one January 6th defendant's move to dismiss an obstruction charge against him. Now, this is a case that could also have an impact on Donald Trump's legal future. I'm going to bring in NBC News Washington correspondent Yamiche Alcindor. Let's start with this January 6th case that the court is hearing today and how it could have important repercussions for Donald Trump. Explain.
That's right, Anna. Well, this case centers specifically on Joseph Fisher, and he is a former police officer who broke into the U.S. Capitol on January 6th. He was charged with obstruction, and it's specifically obstruction of an official proceeding. He's arguing that this obstruction law should not apply to him. It's mainly the case that he's making is that he didn't destroy any records